purpose of this video is to assess whether or not extending safe harbour protection, as recently proposed by Communications Minister Mitch Fifield, will suit the interests of Google Australia. Ultimately, the purpose of safe harbour provisions are to protect carriage service providers. It allows for protection from otherwise unavoidable risk of liability for the unintentional hosting or communicating of infringing material on behalf of their users. An expanded regime will allow for safe harbours to cover online service providers, not just internet service providers. As an online service provider, Google Australia must be aware of how these proposed extensions to the safe harbour scheme may have an effect on their business. It should be noted, however, that the protections provided under safe harbours are optional. So even if the Communications Minister is successful in the extension of safe harbour protection, Google Australia is not obliged to accept the protection that may be offered. At this stage, Australia's safe harbour scheme only applies to commercial ISPs and does not cover providers of other online services. So this means that if an account holder of Google's subsidiary YouTube was to publish infringing material by means of this forum, Google may still be found liable for the publication of this infringing material. There is an argument that limiting the parties to whom the scheme applies is inherent with serious implications on the Australian digital economy. For a non-commercial ISP, it makes Australia a high-risk legal environment for hosting content. This presentation will aim to evaluate this level of risk as compared with other countries that have strong safe harbour frameworks, such as the US and Europe. Examples of such implications on Australia's digital economy are as follows. Global internet companies may be covered by safe harbour schemes operating outside of Australia. This means that if an internet company is operating within the jurisdiction of the US, they are protected by the US effective safe harbours. However, this protection is not covered if they choose to operate within Australia. Local internet companies that host content within Australia have no safe harbour protections. This places those smaller companies at serious disadvantage when compared with global commercial competitors and commercial ISPs to which the scheme applies. This promotes a disincentive for innovation and the creation of local internet companies within Australia. The subject of safe harbour reform in Australia has been a contended topic for over a decade. Most recently, in March 2017, the Australian government dropped their plans to extend safe harbours from the new legislation amending Australia's copyright laws. The intention of these reforms was to bring Australia's safe harbour rules more in line with that of the United States and Europe. It was highlighted, however, that the wider safe harbours had proven controversial in these areas and that there were considerations of reform to limit safe harbour protection for user upload platforms. Lobbyists for content users suggested a more rigorous review should be undertaken before any changes to Australia's safe harbour provisions are to be considered. The reform of safe harbour provisions was dropped from the Copyright Bill until a more detailed review of the scheme could be undertaken. Under safe harbour protection in the US and Europe, search engines, digital lockers, social media and user upload platforms can also claim safe harbour protection. Many have accused Google and others, however, of ruthlessly exploiting safe harbour protections in the US and Europe, forcing copyright holders into an expensive and time-consuming battle to have infringing content taken down. The Digital Millennium Copyright Act of 1998 in the United States failed its aims to ensure a far more equitable online distribution chain. The poor drafting of the legislation and the evolution of the internet currently grants online service providers absolute immunity and effectively quashes the interests of the right holder. Europe's copyright protections are also under review concerning the view that the power of the modern day's online service provider requires the government to restrike the balance in order to achieve a well-functioning marketplace for creative works. Currently, internet intermediaries in Europe already have more obligations to limit piracy on their networks than the US. However, the European Commission has proposed several further requirements in order to reinforce the position of the rights holders. The obvious advantage in extending safe harbour provisions is that Google Australia will not be held liable for their users uploading infringing material. Countries without safe harbour provisions are subject to risks regarding business development and innovation. Being held responsible for millions of other people's infringements could prove massively costly and high risk. Furthermore, without safe harbour protection, Australian startups would be held back from participating in the rich global market for content and ideas. There is an argument that the scheme will also benefit the rights holders by creating a simple system, providing an efficient way to seek the removal of infringing content online. It also operates to protect the legitimate interests of consumers by providing a process through which they may challenge any incorrect claims of copyright infringement. As mentioned earlier, some in the US and Europe have criticised Google and others as exploiting safe harbour protections within these jurisdictions. By allowing for such a wide scope of safe harbour protections in these parts of the world, copyright holders are being forced into expensive and time-consuming battles to have infringing content taken down. While Google would have a significant advantage in not being held liable for their users uploading infringing material, complying with these extended provisions may have negative impacts on Google's public image. Extending safe harbour provisions may potentially have a negative impact on the copyright owners. While Google will be able to enjoy near absolute immunity for liability for copyright infringement, it will severely undermine the ability of creators to negotiate fair terms for their works. For Google Australia, the creation of an open-ended, flexible exception is the best way to protect copyright in the future, so long as it is able to remain applicable to the ever-changing digital environment. If enacted, these safe harbours will encourage greater innovation online by Australian businesses. Ultimately, extending safe harbour provisions to apply to online service providers will have significant benefits to Google Australia. The implementation of these protections means that Google will not be liable for their users hosting or communicating infringing material. It will lower the costs associated with infringement disputes and lowers the risk of liability. Based on the considerations of the safe harbour schemes of the US and Europe, it is likely that the Australian government will be wary as to not allow for online service providers to have absolute immunity and to deter the protections of the right holder. This in mind, if a safe harbour scheme that considered a more equal protection of online service providers and the rights holder, then Google Australia should strongly consider implementing these provisions. Keep in mind, however, these safe harbour provisions are optional, so Google is not obligated to accept the protections that may become available.